Good morning. My name is Tobias Gibson. I'm here to introduce Professor Sean O'Brien of the University of Missouri, Kansas City School of Law. Professor O'Brien is the University of Missouri Curator's Distinguished Teaching Professor. He has been a Chief Public Defender in Kansas City, Missouri. He has been the Executive Director of the Missouri Capital Punishment Resource Center. And he has earned an honorary doctorate of human letters from Benedictine College for his pro bono work on behalf of condemned prisoners. And that's all the introduction you get, because I want you to hear from him, not about him. So without further ado, Professor Sean O'Brien.
Thank you, Tobias. Well, thank you. I'm going to stand down here rather than up there for a couple reasons why I like to be down here where you guys are. The other is that I've gotten hooked on PowerPoints. They've not only become my visual aids, but they're my notes. So this way I can see where I am in my presentation. So thank you for inviting me. I've actually been in this building before, and I'll tell you the story of how I would come here regularly. I used to run a nonprofit that represented people on death row in Missouri, so we would host British students every summer after they took the bar exam and they're waiting for the bar results. So they would work for us on death penalty cases. And, you know, it's quite a schlep from Kansas City, so we'd go see prisoners. And then we would go to St. Louis and spend the night, maybe go to the Broadway Oyster Bar and have a good time. And then the next day we would come back and stop in Wright City at the Elvis is Alive Museum. Has anybody been to the Elvis is Alive Museum? It was run by a guy named Bill Beanie. If you Google that, you can find a little 60 Minutes piece where he believed that Elvis was alive and working in the Federal Witness Protection Program as an undercover DEA agent. I don't know anybody stupid enough to buy drugs from Elvis Presley as an undercover agent. But anyway, he had all of these notes about why Elvis was still alive, and it was impressive, and it was all garbage, and it was great. And the British students loved it, and so to bring them back to earth, we would stop here and see the Churchill Museum so that they could visit that. And then my British students forever after have called this the Churchill is Dead Museum. And so if you ever hear it referenced as that, that's the origin of that. So I feel really especially privileged to be here in this building and in the Churchill Museum. It's just a real honor to be here, so thank you for having me. In this symposium about the rule of law, I want to talk about due process, because you might think from political rhetoric, especially political rhetoric since 9/11, that there are people who are not entitled to due process. That's how we get human trafficking, frankly. Due process is for everyone, and there is no such thing as an individual who is not entitled to due process. And so just to kind of inform the debate and the discussion, I want to take you through a history so that, hang on, this isn't working. I should have, oh, there we go. Takes a minute. So that we can have a discussion with this guy. You've probably seen the Onion headline, "Area Man Passionate About What He Imagines the Constitution to Say." And so you run into this person on the streets every day. He is all over Facebook when they got their Facebook law degree. And there is no way that you could persuade this man from his deeply culturally held beliefs by showing him a text of the U.S. Constitution. We have to understand the history of where we have been and how we got here. And the most important and troubling issue in America is our history of slavery. And our inability to have effectively dealt with that. Probably the most effective thing they did in South Africa was to have a truth commission so that we could confront the reality of apartheid in South Africa. We have never had a truth commission to confront the reality of the Holocaust of American slavery. We never have. But here is the U.S. Constitution that actually frames slavery within the text of the Constitution. The abolitionist movement was very strong at the time this document was adopted. But in order to unify the country, there were some accommodations that had to be made to the states in which it was legal to enslave human beings. So Article 2, you've heard about the 3/5 clause. This was to ensure that rural states where black people were not counted as citizens would be able to fluff up their population in order to have more representation in the House of Representatives. That's why that 3/5 of a person is there. It's not necessarily a statement that we think a black person is 3/5 of a human being, but that's an accommodation to the slave states. The other provision is Article 1, Section 9, that talks about the importation of persons, that is, enslaved human beings. And it guaranteed that Congress would allow that to continue until the year 1808. And so 1808. It guaranteed for another 20 years that the slave trade could continue. And then finally, Article 4, Section 2. Unlike international law, if an enslaved person under international law at this time set foot in a free country that abolished or refused to recognize slavery, by setting foot in that country, they were emancipated, they became free. And if the U.S. was actually a unified, federalized system of independent countries, which is what some people argue, a republic, then that principle of international law would apply. An enslaved person setting foot in a free country or in a free state would thereby become free and not subject to re-enslavement, capture and return. This provision in the Constitution made an exception to that principle of international law. And so here it is, they kind of kick the can down the road, and it comes to a head in the Dred Scott decision, in which Chief Justice Roger B. Taney actually uttered or wrote these words: "The black man has no rights that the black man is required to respect or was bound to respect." That is the essence of the Dred Scott decision. Dred Scott was arguing that principle of international law. If you take seriously the issue of states' rights, I have been to Wisconsin. That act should have set me free. Under all principles of international law and federalism and comity, that is what should have happened. Instead, he was auctioned off of the courthouse steps of that historic courthouse under the Gateway Arch in St. Louis. If you've stood on those steps, you've stood where Dred Scott stood to be sold. And so that was by Roger B. Taney, is how he pronounced his name. There's a county in Missouri named after him, and I don't know why they now insist on mispronouncing his name, but Taney County, Missouri is named for Chief Justice Roger B. Taney. So I'm going to talk about the 14th Amendment Due Process Clause, because the theme of this discussion is due process is for everybody. The framers of the Constitution kicked the can down the road when it came to slavery. They acknowledged that, yes, there is a very powerful abolition movement in this country, and there are states that refuse to enshrine slavery in their Constitution and their laws. But we're just going to not try to resolve this issue right here, right now. And so these issues, when you do that, tend to build. I don't know any problem that gets better by pretending it's not there. And so the 14th Amendment includes a phrase that says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." This is part of the Civil War amendments. This language was crafted in 1868. And so we talk about, when we try to interpret the Constitution, the framers' intent. Well, the framers were deeply flawed, and they wrote a deeply flawed document that didn't resolve this really critical issue of human rights. So now this issue is being resolved, and when people talk about the framers' intent, nobody talks about the framers of the Civil War amendments. And so I want to at least give you a little bit of background and language on who they were, who they are. Wait a minute, I'm going the wrong way. There we go. First is Jacob Howard. He was a U.S. Senator from Ohio. He was also a representative. He is the chief drafter of the 14th Amendment. Also John Armour Bingham, who on the House of Representatives shepherded the 14th Amendment and the Civil War amendments through the House. And his claim to fame is that he prosecuted the Andrew Johnson impeachment proceedings in the House of Representatives. These are probably the two men who are the most responsible for the Civil War amendments that we now have, and a lot of the Supreme Court decisions that have added to our personal freedoms. So when you look at the language of the 14th Amendment, Representative Bingham changed Howard's initial language about who is protected by the 14th Amendment. Originally it said, "No discrimination shall be made by any state or by the United States as to the civil rights of persons because of race, color, or previous condition of servitude." That's how that language was expressed. They replaced it simply with no state shall deprive any person of equal protection, and then stated a simple, strong, plain declaration that equal laws and equal exact justice shall hereinafter be secured within every state, guaranteeing equal protection for, and then they use the language, here's the quote from the 14th Amendment, "any person." Actually, this isn't the 14th Amendment, this is the language from the Congressional Globe. This is the verbatim language of the debates in Congress over the 14th Amendment. Equal protection for any person, no matter whence he comes, or how poor, how weak, how simple, no matter how friendless. That's the language that gives us. So as you read the debates, you see them talking about all of these rights when they're asked, what does due process mean? What is due process? Due process is, first of all, everything in the Bill of Rights. Due process is life, liberty, and the pursuit of happiness. Due process is the right to travel wherever you want and live wherever you want in the United States. Due process is the right to vote, seek, and hold elective office. It's the right to marry who you love. So Obergefell versus Hopkins is contemplated and part of the debate in the Constitution. At the time, I think they were talking about miscegenation laws. And so just to give some perspective on how recent some of the, it is in our history that some of the ideals of the framers of the 14th Amendment have come to fruition. I was in junior high school when the U.S. Supreme Court struck down Virginia's interracial marriage laws, their anti-miscegenation laws. And so it's very recent history. It used to be that it was a crime in order, for you to marry someone outside your race. And so the congressional record, this is really interesting language to look at because Jacob Howard is saying the 14th Amendment throws the shield over the black man just as it does the white man. And people who supported it agreed that's what the language does. People who opposed it because that's what the language does. And so you see a very robust, in many ways, racist debate in Congress, and Jacob Howard's views prevailed in the passage of the 14th Amendment. So here's the interesting thing about the 14th Amendment. The same term that this language, the same term of Congress that this language was agreed upon and sent out to the states for ratification, they expanded the scope of habeas corpus. You know, everybody knows what habeas corpus is, right? It means have the body. It is the legal proceeding by which you can haul your custodian into court. So it's a lawsuit against the prison warden, is the way we generally, most commonly see it, saying that your custody of me is unlawful because my trial was conducted in a way that violates the Constitution. Right? That is the essence of habeas corpus. So you see the tweak, the change in the language of the habeas corpus statute. Any person in state custody in violation of the laws, Constitution, of treaties of the United States may petition a federal court to issue a writ of habeas corpus. That word state was added so that the federal courts can now enforce the Constitution on behalf of state prisoners. Really significant step forward in individual due process. The intent of the amendments to arm Congress with the power to enforce the Bill of Rights. Also among the debate was the right to come to federal court to enforce your constitutional rights against infringement by state action. Unfortunately, before Frank v. Mangum, we had a near constitutional crisis similar to what we have been experiencing lately, a virtual tie vote for president. And the U.S. Supreme Court selected the president, who turned out to be more of a Southern sympathizer, and appointed a Supreme Court that handed down several decisions that hogtied the 14th Amendment. The first were the slaughterhouse cases. You guys probably have read about the slaughterhouse cases. It said due process isn't really a thing that can be enforced in federal court. Then there was Cruikshank versus United States, where a U.S. attorney prosecuted Cruikshank and several others for a lynching that occurred, and Cruikshank appealed to the U.S. Supreme Court, and the Supreme Court said, well, that's not a federal constitutional issue. And so they discharged him. They dismissed the case because didn't have the jurisdiction to prosecute lynchings, right? Oh my God, that's where we are. So from, and then of course there's 1898, the Plessy v. Ferguson decision. Separate but equal is just A-OK with the Supreme Court. So the Supreme Court essentially in the late 19th century enabled Jim Crow contrary to the explicit intent of the framers of the Civil War amendments. If you want to look in our history for a case of judicial activism, that is it. It is the Supreme Court nullifying the Civil War amendments. But it begins to awaken. First, not really awakening here in a case called Frank v. Mangum. Leo Frank was convicted in the state of Georgia for the murder of a young white Christian woman named Mary Fagan. He was a Jewish man who was a manager of a pencil factory in which Ms. Fagan worked. She was brutally murdered and left in the bottom of an elevator shaft in the basement of the factory. The custodian claimed to have seen Leo Frank in her company. They called a bunch of witnesses who said that he was made inappropriate advances to young female employees. It was really kind of a trial by character assassination. The governor had to call out the National Guard to escort him from the jail to the courthouse so that he would not be lynched. This is a photograph. In this lighting, you may not be able to see it very well, of the courtroom, but these are all citizens and also people who are members of the lynch mob, but also media, so crowded that at the council table, you've got newspaper reporters looking over your shoulder and being able to take pictures. And on the far wall, that's the jury. So if you're on Leo Frank's jury, your picture now is just in the front page of the paper. Does that sound like a fair trial to anybody? If you're on that jury, do you feel free to acquit Leo Frank under those circumstances? So he is convicted and sentenced to death and appeals his case to the U.S. Supreme Court after having gone to the Georgia Supreme Court. The Georgia Supreme Court looked at all of this evidence and said, nah, that's not a problem, and denied him a new trial. And the Supreme Court said, well, as long as the Georgia Supreme Court looked at it, that's all the due process he's entitled to. And so that was, the end of the legal case. After the Supreme Court affirmed Leo Frank's decision and said that, you only get to come to federal court if the state court denies, refuses to hear you, period. And if they hear it and they deny it, we're not going to look at it. The trial judge was on his deathbed and wrote the governor and said, I do believe that Leo Frank is innocent. I cannot go to my deathbed without writing this letter to you and imploring you to stop this execution. And so the governor did. The governor commuted Leo Frank's death sentence, and then a lynch mob surrounded the prison. The warden shuffled him out the front door, and they took him and they lynched him. They lynched him. That was the end of the Leo Frank case, and it kind of left a bad taste in everybody's mouth. In 1986, the Georgia governor pardoned Leo Frank because even after his death, the Reverend Dr. Martin Luther King says, truth crushed to earth will rise again. His innocence became more and more apparent by legal scholars writing books, investigating the case, looking into it. And so finally, years after his unjust death, he was posthumously pardoned for his offense. So just a few years later, the Supreme Court is confronted with a similar case involving similar circumstances. Anybody here read or heard about the Red Summer of 1919? It's part of our history. It's good that you do know about it because in World War II, people of all races fought together for America. Native Americans, Black Americans, Latino Americans, and in Europe, they experienced a society without Jim Crow. And they came back to the U.S. wanting to know, how can we make a society without Jim Crow? How can we exist? Once you see injustice, it's hard, right, not to see it. Once you see racism, you can't unsee it. And so we saw Black Americans asserting themselves, wearing their uniforms in public and asking for the same respect, to be able to ride the buses just as a white person would, to be served at lunch counters just like white people. And the response was extraordinarily violent. In 30 cities, we saw white mobs rise up and destroy Black communities. East St. Louis, Elaine, Arkansas, Fort Smith, Tulsa, Oklahoma, the Black Wall Street that was literally burned to the ground by a white mob. And so the Supreme Court realized, Crookshank isn't such a good thing. Due process should be protecting everybody, and, this mob justice is the quintessential denial of due process. And so the court in Moore v. Dempsey reversed the course that it had taken in Frank v. Mangum. Frank Moore and his co-defendants were farmers who were meeting in a church discussing how they could unionize so that they could borrow seed money on the same terms as white farmers. All right, so you've probably heard the term seed money. Literally, in the rural community, it is that the farmer borrows money to plant the seeds. and then you grow your crop, and then you sell your crop, and you repay the loan from the proceeds of the sale. Black farmers were charged more interest and higher costs than white farmers. So they were talking about unionizing. And then men on horseback riding around the church during this meeting started firing rifles into the windows of the church. And the black farmers returned fire, killing one of the white men. Then the National Guard is called out. Then there is a huge mob. It's estimated that over 200 black men, women, and children were chased down and murdered in the fields and in their homes. And then Frank and his co-defendants were convicted and sentenced to death for having participated in that homicide of a white person, right? Probably self-defense, but no jury heard that. Within a week, the governor actually was quoted in the newspaper in Little Rock as saying, "You better get them tried and hung quickly because we don't want any lynchings," right? So in other words, we should have a legal lynching. That's what their trials were. Same as Leo Frank, they had to call out the National Guard, courtroom dominated by a lynch mob. The lawyers who were nominally representing them didn't cross-examine any witnesses, didn't do anything to impanel a fair jury, didn't make any arguments, just simply they were literally persons with a law license and a pulse, and that was it. That's all they got in terms of legal representation. So again, we have a trial that is an abomination of due process. This time, the Supreme Court says, you get a new trial. If you were convicted in violation of the U.S. Constitution, you can come into federal court, you can prove your case. Now, there's a big give and take and tug of war since Moore v. Dempsey about the power and the duty and the scope of that power and duty of federal courts to enforce habeas corpus. I teach a 3-credit-hour semester-long course, and I'm not going to try to pretend to give it to you here this morning. You'd all leave here half asleep. We're not going to do that. But Moore v. Dempsey is an important milestone in that due process debate, and it opened up the federal courthouse doors a little crack now so that state prisoners can get into federal court with their constitutional claims. Even through the 1930s, this is a political cartoon from the Richmond Planet. The struggle between mob rule and the Bill of Rights. This is the point where Justice Thurgood Marshall, as a death penalty defense lawyer, is beginning to have some influence on the Supreme Court's jurisdiction. So we do get due process that is given specific meanings. In a case called Painter versus Texas, the U.S. Supreme Court said that beating a confession out of a prisoner is a violation of due process. We cannot use a confession obtained in that way to obtain a conviction. And so we see with the Warren Court, people talk about the Warren Court as an activist Supreme Court, and I argue that vigorously because Warren was the first Chief Justice to embrace the vision of the drafters of the 14th Amendment and to give it its literal meaning. So you want to talk about strict construction. Chief Justice Earl Warren looked at equal protection and said equal protection means, separate is inherently unequal, right? And so we begin to see the framers' vision that the Bill of Rights would apply to the state government and limit the power of the state government. That becomes part of the Constitution through the Warren Court. And we actually have seen the Roberts Court continue that work in Ramos v. Louisiana that took the right to a unanimous verdict by a jury using critical race theory, and it was Neil Gorsuch who wrote the opinion explaining why a 10-2 verdict violates the due process clause of the Constitution because our tradition is unanimous verdicts, right? So Justice Warren's vision is still with us today, even though it's under attack. But all of these cases added to the Bill of Rights specific guarantees. I have actually met Gary Duncan v. Louisiana, whose case added we could have a discussion about that, but you know, a lot of legal scholars say that this is the case that added the right to a jury trial to the 14th Amendment due process guarantee. That there may be a 1906 Supreme Court case that may have done it earlier, but largely was ignored. Interesting, and then a Missouri connection. You know, you've all heard Gideon versus Wainwright. Anybody know he was a Hannibal, Missouri? You knew that? All right.
Gideon versus Wainwright is one of my favorite cases because it's so interesting how it got to the court and who's involved and who his lead counsel was to represent him.
Abe Fortas. He went from having no lawyer to the best lawyer in the country, right? Yeah, and later became a Supreme Court justice. Well, this is his tombstone. He's buried in Hannibal, Missouri. And I really recommend the Henry Fonda film, Gideon's Trumpet, which is based on actual transcripts from the trial. I show it to my criminal procedure students because it shows Clarence doing his own trial, not doing very well because he's not a lawyer, goes up to the Supreme Court representing himself all the way until he gets Abe Fortas. Then he gets a new trial. And then you see the same case tried with the skills of an attorney. And you go from thinking that he's a guilty ne'er-do-well to, oh my God, he was innocent all along. He's telling the truth. And so he gets acquitted on his retrial. So it was a well-chosen case. And it's an excellent example. And so, you know, well, the one thing, so that's our due process journey. To get into the 20th century, now trying to flesh out the vision of the framers of the 14th Amendment, but something happened on September 11th, 2001. I was doing parole hearings. Everybody my age would tell you, here's where I was in the Kennedy assassination, here's where I was when the space shuttle exploded, here's where I was when the towers went down. I was doing parole hearings in the Missouri State Prison. And it was actually a prisoner who told me, and he was very tearful to say, oh my God, they've hit the tower, they brought down the towers. And so the aftermath of that, the war on terror, a lot of people were led to believe by rhetoric coming from the administration that if someone was an enemy combatant, that they were not entitled to due process of law. And there is no such thing as a person not entitled to a due process of law. So I want to track some of that language. We really need to be careful in our discussions about the language that we use, because I don't think the administration intended to say there are people in our presence who do not deserve and are not entitled to due process of law. But that was how the message was received in a lot of quarters in America. And so, when the war on terror, the war on drugs, and now our immigrant policy, we are looking literally at due process for undesirable people. So I've spent my whole career working on due process for undesirable people, people on death row, and I do bring some of my spirituality to this work. I was raised Catholic. Everybody knows that's a euphemism for adult non-practicing Catholic. But I was raised Catholic. And I was taught to believe that what you do to the least of my brothers, you do to me. And so I focus on that word least, and I think I know where to find them. You can find them on death row in Potosi, Missouri. That is, who we are if we pretend to be a Christian nation. So, who has no entitlement to due process? Actually, that should say none of the above. They all have entitlement. So I want to take you back to Korematsu versus United States. It's a decision following the Second World War. Everybody here has heard of Korematsu v. United States. I have met Fred Korematsu. He is still alive. And one of the cases I'm going to talk about, he actually filed an amicus brief in favor of the petitioner. Also, any Star Trek fans in here? So Lieutenant Zulu, George Takei, was in the internment camp as a small boy during World War II. So this was the order that went out that was enforced on a state level by governors, and one of the architects of this order was the governor of California named Earl Warren. I feel like he spent his time on the Supreme Court doing penance for making amends for this horrible thing. But virtually everybody in America regards the Korematsu versus United States decision that said, in a time of war, national security gives the government the power to round up persons of Japanese ancestry and place them in internment camps for the safety and the national security of the United States. That's the literal holding of that decision. And while it hasn't been formally overruled, it has been repudiated and criticized by every government body, including Congress and the U.S. Supreme Court. In the 1980s, there was reparations paid of $20,000 for every individual who was interred. And the Supreme Court 2 terms ago called it an abomination of due process, right? So Korematsu versus United States pretended to think that it was okay to round up people based solely on their ancestry. But I want you to know about a case called Ex parte Endo that followed Korematsu, about a woman named Mitsuye Endo, who was also interred, and she sued in habeas corpus to be freed from the camp because she was not disloyal to the U.S. government. She made the allegation that she was a loyal citizen of the United States and that her internment was unlawful. The government responded saying, "We agree that we have no evidence that you are disloyal to the United States." And they virtually stipulated to that. You know, the defense lawyer is very wise and says, "Oh, you can stipulate to that? I'll stipulate that she's not disloyal." And the U.S. Supreme Court says, "You know, this internment order was based on a factual assumption that you are disloyal. And due process requires that if there is a factual assumption behind your incarceration, that you be entitled to rebut that fact." And therefore, they said, so within the internment camps were loyalty commissions. I mean, that sounds kind of offensive, but it was a way in which people could come and prove their loyalty and be released from the camps. And so there were hundreds of people who managed, who succeeded in doing that. And this was the precedent. So even at that time, no such thing as a person not entitled to due process. And so it's a really important precedent. At the same time, Ex parte Yamashita, this brings us more current to the post 9/11 debate about enemy combatants, right? Does anybody here think enemy combatants have no right to due process? You don't have to hold up your hand because I don't want to embarrass anybody, because the answer to that question is, yes, they do have a right to due process. And that's a right that is founded in international law and in American law. The label enemy combatant doesn't mean that you can be incarcerated and executed for no reason or incarcerated indefinitely. So General Yamashita was in charge of the Philippine forces, and you've all heard the phrase, "I shall return," right? So when General MacArthur retreated from the Philippines, he says, "I shall return," and by golly, he did, with overwhelming force, and discipline among the ranks of the Japanese soldiers just broke down, and there was raping and pillaging and plundering all the way across the Philippines as the U.S. Army was driving the Japanese before them, and Yamashita was blamed for having allowed that to happen and prosecuted for those war crimes, right? That made him an enemy combatant, an unlawful enemy combatant. It's a so there are two things. There's an enemy combatant who is a soldier who can be captured and held humanely without torture, interrogated only under limited means, legal under the U.S. Army Field Interrogation Manual, but at the end of the war, they are repatriated, just as we expect our soldiers to be treated. They're not criminals. There are people doing their civic duty out of loyalty to their country, fighting for their country. And so that's the enemy combatant. The unlawful enemy combatant are war criminals, spies, and people who commit acts of terrorism or sabotage. Those would be unlawful enemy combatant, ununiformed people who sneak around and cause great harm. So if you are an enemy combatant, you get this treatment. If you're an unlawful enemy combatant, you get a different treatment. You can be prosecuted for your crime and sentenced and held until you served your sentence, or if it's a capital crime, you can be executed. And so after a trial, General Yamashita was found guilty and he was executed for his crime. This is his last meal. He was executed as an unlawful enemy combatant after receiving due process. And the Supreme Court looked at his arguments, considered his arguments before allowing this execution to go forward. So here we are. That's our precedent. And Camp X-ray comes along after 9/11. So we heard that term enemy combatant bandied about like there's no due process there, but there is due process for the enemy combatant. And so the Camp X-ray cases, the U.S. government was 0-6 in the U.S. Supreme Court on their attempts to justify what happened at Camp X-ray. And I point that out because the U.S. government is not doing so well with the current war on immigrants either, because so much of what is happening without due process. No mistake, the Biden administration deported a lot of people, as did the Obama administration and the Bush administration and the Reagan administration before that. But they did so using due process. They did it with judges and lawyers, not with force. And so federal habeas corpus does extend to enemy aliens. In Rasul v. Bush, Hamdi v. Rumsfeld, due process forbids indefinite detention without notice of the charges and an opportunity to defend. There are people in Guantanamo still who have been there for 25 years and no trial, right? And in Hamdan versus Rumsfeld, Hamdan was Osama bin Laden's chauffeur. The military tribunal jurisdiction has to be explicitly conferred by Congress. So there's got to be a law in place before we can treat people in this way. Hamdan, I don't need to go over the legal part of it, but they first tried to say that because Guantanamo is outside the borders of the U.S., that there is no jurisdiction in habeas corpus of federal judges. And the way I like to describe Hamdan versus Rumsfeld in lay terms is that if you have any question about whether the U.S. Constitution applies where you are in the court where you happen to be in, step outside and look at the flagpole and see what flag is flying on top of it. And if the U.S. flag is flying, due process applies in this courtroom, in this government building. And so essentially Hamdan versus Rumsfeld holds that. Probably the most important case is Boumadjen versus Bush, in which Lakhdar Boumadjen was arrested as a suspected terrorist in Serbia. And he appealed to the European Union. The European Commission on Human Rights ruled that there was zero evidence, and the U.S. government refused to show their evidence. And so they ordered him released. The Bush administration brought diplomatic pressure to render him to the U.S., and they put him in Guantanamo with no evidence, with nothing indicating that he was guilty of anything. And the U.S. Supreme Court says, Article 1, Section 9, Clause 2, the writ of habeas corpus shall never be suspended, has full effect at Guantanamo Bay. And they allowed him to pursue habeas corpus. And the combat status review tribunal procedure was examined. So the combat status review procedure was really designed by the CIA to protect national security. So here's how the process works. If, again, I put the process in lay terms, the prosecution could say, someone, we can't tell you who, told us that you did something, we can't tell you what, that endangers the national security of the United States, we can't tell you how. And you're not entitled to present evidence to contradict those allegations. That is literally how they worked. Dressed up in somewhat more legalese language, but that was the essence of it. And the Supreme Court also looked at the fact that the statute allowed the introduction of confessions extracted by torture, as long as they were reliable, right? There's no such thing as a reliable confession extracted by torture. And so these were essentially violations of due process. No notice of the factual basis for detention. The information, the whole point of this was to protect classified information, and no opportunity to rebut factual assertions, and the decision maker is far from neutral. I was advised that the report that I'd submitted to the tribunal on what due process required has been declassified. I was an expert witness for some of these. And so it's not controversial that you're entitled to due process, no matter what the accusation. And the Supreme Court said liberty and security can be reconciled within the framework of law. And so that's our job as citizens of the United States, is to respect due process. Everyone is entitled to due process. It's not open borders. That's not true about what our position is. Governor, it's good to see you. It is, pardon me? Oh, do you? Come on. Happy to have you. All right. And so, so it's an important milestone, and it's something for all of us to remember. There's no such thing as a human being who is not entitled to due process of law. And that is, doesn't mean prosecutors can't punish. It does mean that when they do punish, it has to be by due process. And so the Roberts Court today, in a case called Noam versus Garcia, you've all heard about Kilmar Armando Abrego Garcia, who was sent to El Salvador, now has been brought back, and he's undergoing a prosecution now. But the Supreme Court required them to return him to give him due process, even though he is alleged to be an enemy combatant. And so Justice Sotomayor, agreeing with the majority of the court, says that means the government must comply with its obligation to provide Abrego Garcia with due process of law, including notice and an opportunity to be heard. So if somebody's here on a valid green card, you can't just orally declare that green card invalid, take them into custody, and deport them. They're entitled to due process and make the government prove the facts that establish that their green card should be revoked. And in the process of doing that, their rights under federal and international law should be respected. So asylum, I just want to kind of inform you, because these things are getting kicked around. People have a human right to come into the United States at any point and present themselves for asylum. It's not unlawful unless they fail to go to a government office and present themselves and assert their asylum claim. They have an absolute right to do that. That actually was embodied in federal statute because of a ship called the St. Louis, filled with Jewish refugees from Germany, that was refused to dock at New York and return to Europe. And some of these people ended up in German concentration camps during the Second World War. And in Congress, the sentiment was never again. Our borders are open to asylum. And so asylum seekers have a right to be here. Now, that doesn't mean they get to say asylum and they get to stay. there is a due process for resolving that asylum claim, at the end of which they can be put on a plane and deported. So they can apply. The other thing about immigrants is that it's not per se a crime to walk across a border unauthorized. It becomes a crime when you lie, when you use false papers, when you don't do it at a point of entry. Other than that, it's a civil infraction, kind of like parking in the wrong place on campus and you get a ticket, right? That's the level of the severity of entering the U.S. If there's any fraud, it becomes a misdemeanor. But there's also kind of a right to have a lawyer come and argue your case. And this is also closely related to human trafficking. If you were, I love the panel discussion this morning, by the way. I like the sensitive discussion of human trafficking. And it kind of persuaded me that private prisons are a form of human trafficking because you're taking people for profit. But they're entitled to bail. That doesn't mean they get released on bail, but they can apply for bail and then they show up for their hearing. And they can apply to be allowed to work. And then they can legally work in the U.S. The law accommodates all of this, and there is an orderly process that can be applied without all of the drama and the arbitrary treatment that we're seeing for some folks. Freedom from bodily restraint has always been at the core of the liberty protected by the Due Process Clause from arbitrary government action. That is Justice Sandra Day O'Connor, no flaming liberal, in the context of an immigration case. And so it's important. So my own work recently, I do a lot of, just a ton of habeas corpus work, but I also work in innocence cases. Representing prisoners. Some of you may have followed Sandy Hemme, who was released from prison last summer. She served 43 years, 7 months, and 21 days in prison for a crime that she didn't do. Our investigation established that the crime was committed by a police officer. She's now back with her family in Higginsville, Missouri. She would die there if it were not for individuals doing pro bono legal work, asserting her rights to due process, to point out how she was tried in violation of the due process rights. I've kind of color-coded this so that you can see. The red didn't show up for some reason. There are 4 exonerees who, and this is since 1980, who were exonerated from death row. You'd think those would be the most reliable. Each of them tried, convicted, sentenced to death, and then found innocent and released. The green ones, where you see the little red, those were DNA exonerations. You see, that's a small percentage because you can only exonerate somebody with DNA when the real perpetrator leaves body tissue behind, right? And that's usually in a sexual assault case. So those are relatively rare. The blue ones are conviction integrity units, prosecutors now getting into the business of correcting false convictions. The purple ones are innocence organizations. The Innocence Project did 2. The Centurion Ministries did 6. Miracle of Innocence did 1. I should update that because I'm now the president of a nonprofit called the Investigation and Advocacy Service. And there are 15 names on that are exonerated by the work of individuals connected with the Investigation and Advocacy Service. And then the yellow, the most common color, those are non-governmental, non-institutional, simply private pro bono lawyers who take on cases out of the goodness of their heart. And what you see is a system that literally functions on the charity of lawyers and whatever else you think about lawyers. I mean, I'm a lawyer, and 99% of them give the other 1% of us a bad name. But it's so important to understand how much of this work is done. And there is Sandy today. I always have to show a picture of Sandy because, this is the work that I'm dedicated to, and that, there's so many ways to do to make the community better. And if you sat in on the panel discussion this morning, what an incredible blueprint for becoming involved in your community. But my main goal is to help you be involved as an intelligent person and not be that guy in the Onion article who's defending what you imagine the Constitution to say without knowing what the Constitution says. And then final shameless plug, if you're interested in teaching post-conviction remedies, here's, and I've just given you the second chapter of my post-conviction remedies textbook. If you're in my class, you would have heard something a lot like this. And so there we go. I maybe have a few minutes, maybe 4 or 5 minutes for questions, if anybody has any.
So several of the cases that you mentioned on that list are cases that are held via substantive due process. And most recently, in 22, I believe, the Dobbs decision was handed down, which essentially sidestepped, or at least the majority in that case, sidestepped due process in their opinion. However, in Clarence Thomas's concurring opinion, he basically goes on to say that this is the tool for which you can use to take down other substantive due process cases, which I believe, I'm not the lawyer, so I believe it goes all the way back to Gideon, but I'm kind of curious of what you think about this administration's, not just assault on due process in general, but, the assault on substantive due process specifically,
Yeah.
which more focuses not on the procedural, but on the, overarching identity and liberties of it.
Yeah, that's very interesting. He's talking about the Dobbs decision and Justice Thomas saying, here's our blueprint for undoing due process. It does not bode well for due process in America. It is a dangerous decision. It's dangerous language for the U.S. Supreme Court to be using. There are only 3 justices that embrace the extreme view that Clarence Thomas is. Justice Thomas, Justice Alito, and in some instances, Justice Gorsuch. So there is some risk of significant backsliding because there, is a faction of the Supreme Court that wants to take us back to pre-Warren era cases. And in fact, Justice Thomas and Justice Gorsuch have both written opinions in which they said we should return to the rule of Leo Frank. The Frank v. Mangum case is the only time in American history that the U.S. Supreme Court has said that federal courts have no business enforcing due process other than if the state court heard the claim, we shouldn't hear it here. And so there is a danger to due process, and I think that we will have to fight to protect habeas corpus from further encroachments. There have been a number of opinions where the Supreme Court has limited habeas corpus in technical ways, and at the end of every term we get together and say, oh God, how are we going to argue our way through this morass? Yeah, that's a good point. There is a risk. We are in danger. There's no question about that. Yes, sir. So due process is something the government is obliged to do. Individual impulsive behavior has never been a subject of the due process clause, but someone who shoots the police can be prosecuted as a criminal, and if given due process in many states, they can be executed for that conduct. Virtually every state has what's called a Victim's Bill of Rights statute or constitutional provision. Missouri has both. And under Missouri law, if the victim of a shooting, a homicide, is a police officer, that's an aggravating factor that can justify the death penalty. Yeah, it is, crime is something that is always going to be there. Society must apprehend and punish criminals, but they must do so in a way that comports with due process. I also work with families of prisoners who have been executed. I've worked with families of innocent prisoners who have been executed. And they don't feel good about the level of or quality of due process that they received. But it's different when the government acts like a criminal, right? There are criminals among us, and they must be detected, apprehended, rehabilitated if they can be, but punished according to due process. We give due process as a society. One of the arguments about immigrants is that if they sneaked in, they came in without due process. They're individuals. Due process is a government obligation. It is how we act collectively and how we want people on our behalf to act when confronting these social issues. I saw another hand over. Oh, sorry.
Please, we will see you at 2 o'clock in Champ Auditorium for the Green Lecture. Please thank Professor.